Welcome back to another episode of Grizzly True Crime. My name is Grizzly, and today we're going to do a deep dive from the defense's point, because we've already read through the state's motion for a protective order. In this case, now if you don't even know what this case is about, this is about a case where 4 University of Idaho students were brutally murdered on November 13th of 2022 in their off-campus college home in Moscow, Idaho. Their names, never forget their names because that's what the case is about: Xana Kernodle, Ethan Chapin, Madison Mogan, and Kelly Gonsalves. On December 30th of 2022, a suspect was arrested, Bryan Kohberger. And so we're talking about his defense team, which are death penalty qualified, and what they filed now in response to the state's motion for a protective order, where they explained how they even got to Kohberger using genealogical sites to trace that microscopic DNA that was left on the button snap of the knife sheath, which was found near Madison Mogan's body, and all of that was traced to Kohberger. We've gone through all of that. So if you are aware of the case and you've looked at that playlist, welcome. Today, we're going to look at what the defense has said in response to that. And tomorrow, as you can see here, is an extremely important hearing, because there, the prosecution and the defense are probably going to be arguing about all of this, which is going to be very interesting. Now, there's one document that has been discussed at length lately, right? This past week, on YouTube, on Twitter, and everywhere. And I get why it's important, because the defense is saying there's no explanation as to why there's none of the victim's DNA in Bryan Kohberger's car, apartment, office, or his parents' house. So that has got the internet abuzz. And I get it. What I will say is I think the defense is doing a really good job at poking holes in the case and creating some doubt. So what I want to do is, this is what I always do, right? When I'm trying to be like, wait, let me get a grip on this. What is happening? Why is it happening? Let's try to think of this logically. Then what I want to do is read all the documents, right? How did they get to that document? What happened before that? So we're going to look at that today. We're going to be reading through about 64 pages, and wish me luck, because I've got a cold, which I'm sure you can hear. So wish my voice lots of luck. So anyway, I'm committed to doing this because when I was just sitting here reading through it, I found it very interesting, as I did the other document. I never find documents boring. In fact, I find them very interesting. So I'm a nerd like that, and I'm guessing if you're here, then you're one too. If you're not yet part of this community, please do hit the subscribe button, bell on, set to all, so you don't miss another video upload or a live stream. I predominantly go live on this channel. A community post perhaps might interest you, or a YouTube short. They also make updates. I've already spoken about that one paragraph, and that they're going to allow cameras in the courtroom, and those little updates on my community tab and in YouTube shorts. So if you didn't see those, check those out as well. But today, I've had lots of coffee and a Red Bull, okay? I'm ready to tackle these 64 pages to see, well, what is this all about? How did they get to it? And by now you're saying, just get on with it, woman. Okay, we're getting on with it. Let's get started.
Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share.
So, this hearing tomorrow, State of Idaho Plaintiff versus Bryan Kohberger, date June 27th, 2023 at 1:30 p.m. What is it about? Notice is hereby given that Bryan Kohberger, by and through his attorney, Ann C. Taylor, public defendant, will call on for hearing the defendant's third motion to compel in the above titled matter on the 27th of June, 2023, 1:30 p.m. or as soon thereafter as counsel may be heard in front of the Honorable Judge John Judge. And yes, the judge's name is Judge. Indeed. I see some of you only found that out recently. So on my community tab, you're like, wait, is the judge's name Judge? Yep, it is. Counsel for the defendant hereby gives notice of the intent to present oral argument and or testimony in support of said motion. I think this is going to be one of the most interesting hearings yet in this case. Let's see what happens. I want to hear what does the prosecution say? What do they say back? Do they say, Well, yeah, we know. We know there's no DNA of the victims in his car, apartment, that. Or did they say, well, no, that's actually incorrect. There is DNA, we just haven't said what it is, because we wait until trial. You know what I mean? Is it the defense just, throwing things out there to see what they come back with? Or will the prosecution admit, there's actually no DNA of the victims connected to Bryan Kohberger? Which, I will say, maybe he dextered up. Maybe he brought a kill kit like BTK did. But, Kohberger's would then be new and improved, unfortunately. Maybe he really dextered up. Maybe he wore an outfit over that outfit. The man clad in black with his bushy eyebrows, but then with, I don't know what, over it. I'm always trying to imagine all the possibilities. I wouldn't doubt that he brought like a duffel bag with him. I wouldn't doubt that he used different, or whoever the alleged killer is, used different weapons on either each victim or the upstairs ones or the downstairs ones, all of that. So I really think we're going to learn a lot from this trial. But either way, I always find DNA and DNA evidence and all that very interesting, especially in a case like this where it all sounds very circumstantial. If they didn't have that knife sheath, what did they have? What, like an Elantra, a white Elantra going round and round? Which, how do we know what car the DoorDash driver drove? You know what I mean? I know there's a lot of theories on that as well. I myself have done a deep dive on the Bryan Kohberger theory. It's what feels like years ago now. I will link that too. If you haven't seen that, check out the playlist, find it there, and I'll link it for you because that was a deep dive. I think we spent about 3 hours on that, being like, and this, and what about that? There's just so many connections there. Anyway, let me actually stop waffling here about this. I'm very excited to see what happens here because we have about 64 pages to read, not including this one. So off we go to the next one that I pinned for you. This one is 26 pages long. So they say here, declaration of Ann C. Taylor in support of the defendant's third motion to compel. I, Ann C. Taylor, do state and declare, 1. Counsel for Mr. Kohberger filed a specific request for discovery related to the DNA, in this case titled Defendant's Third Supplemental Request for Discovery. Before I get to point number 2, use that little gear toggle and slow me down if you want to. Okay, don't tell me I'm talking too fast for you because I'm talking how I talk and we have 64 pages to get through. If I'm going to be reading slowly, will be a forever. So I'm going to read at my normal pace. You can slow me down. You can even speed me up. For those who like a challenge, put me on 1.5 speed and see how that goes. Okay, so number 2, the state filed a specific response to that request. After reviewing the materials provided, the following remains to be discovered. A. Request 3 profiles uploaded to a DNA database. The state has provided information related to this request for the seized item, the knife sheath only. The defense has requested all DNA profiles, including 3 additional unidentified male DNA profiles developed during the course of law enforcement investigation. This information has not been supplied. Oh, now, to that, I will still say, I'm amazed that it's not like 300 unknown or unidentified male DNA profiles. I say that because of the amount of people, as we even saw on the body cam footage, that were going in and out of that house. Like so many people partying there, college kids moving in and out, partying in and out. So, okay. But still, they say what they're implying here is that there were 3 additional unidentified male DNA profiles developed during the course of law enforcement investigation. Interesting. Then they say, B, request 6, communications. The state has not provided all emails, text messages, electronic messages, or other messages and conversations regarding biological testing in this investigation. C, request 9 and 10, unexpected results and corrective actions. This request has been partially complied with, however, the response lacks the full scope of the request. 6 months before and 6 months after testing related to this investigation. Further, information relating to all lab personnel has not been provided. Now, when we hear from the experts in the next 2 documents after this one, which will be a while, okay, so stick around, we will hear why they say that. 3. Part of the third supplemental discovery request was for materials related to genetic genealogy testing. The state has objected to this request in its entirety and has filed a motion for a protective order. Counsel for Mr. Kohberger requests this court consider the contemporaneous objection to the state's motion and declarations in support of the motion to compel. If you can't tell, I'm not a lawyer. No, I'm just a normal person like you. Maybe you're a lawyer, actually. A lot of experts here in the community. So if you are one, sorry if I'm botching any of the words, but I'm just normal layperson, South African in the Netherlands, reading through this American document and being like, wait, what? So here we go. They say, and declarations in support of the motion to compel. The requested discovery is properly sought pursuant to Idaho Criminal Rule 16. The discovery is necessary to the preparation of Mr. Kohberger's defense. 1. The counsel for Mr. Kohberger has reviewed the materials provided in this case regarding the DNA testing, lab reports, bench notes, photographs. Further, experts in the field of genetic genealogy and DNA have consulted and offered information and guidance. We're going to look through what they said. The state acknowledges it used genetic genealogy testing in this case, but claims it does not have to produce the records in the specific request for discovery. The defense disagrees. 2. Counsel has learned, through consultation with experts and sources referenced below, that the use of genetic genealogy databases does not necessarily lead to a single individual as a potential suspect, and that reports of these searches often reference multiple individuals for further investigation and DNA testing. To that I will say, they say that what if it was a relative of Kohberger's? What if it was anyone else on that family tree that could have been in the area of the crime at the time? Well, that will be quite the plot twist, like some cousin out of nowhere, right? Out to get Kohberger. But you never know. I get that they want to be able to, for the state to prove that they at least eliminated those other connections. Okay, so to continue on. In fact, the state acknowledges such in its motion for protective order when it acknowledges hundreds of relatives. Page 5, motion for protective order. The testing conducted by a private lab is completely different in nature than the testing done by forensic labs. Genetic genealogy labs do not generate a profile in the same way that forensic labs do, and there cannot be a direct comparison between the data obtained in this case by the Idaho State Forensics Crime Lab and private lab. The tests used by the private labs are either SNP, single nucleotide polymorphisms, or whole genome sequencing. These tests are similar to the methods used by commercial services such as 23andMe and Ancestry.com. I will insert a little picture of my Ancestry.com results for you guys. Let me write down the time. This is at 12 minutes and 16 seconds. I'll insert that for you if you are interested in seeing that just while we're at it. So, 3. Based upon information from experts in the field, I've learned that once a genetic genealogy profile is created and the testing by the private lab is completed, the profile is uploaded to a database or database that contains similar data from other individuals. Once the genetic genealogy profile is uploaded, the profile is compared within that database and relatives are identified. It's my understanding that once possible relatives have been identified, their identities are used to construct a family tree, to identify possible suspects using public records and, in some instances, contacting individuals for further family information. This process leads to a pool of individuals rather than one specific individual. The possibility of other relatives who might be similar to Mr. Kohberger is extremely important to the defense in this case. The processes used in this method of identification may be extremely important to Mr. Kohberger's defense. The timing and steps utilized are extremely important to Mr. Kohberger's case investigation and defense. I reviewed a copy of an Idaho State Police announcement dated July 28, 2021. That the Idaho State Police Forensic Services Lab, ISPFS, secured a grant to fund genetic genealogy testing for unsolved Idaho cases. See attached Exhibit A. ISPFS contracted with Othram Laboratories in Texas. I remember that. At some point that was like conspiracy, but there it is. You know, they do say that when they couldn't themselves, this was rumor, okay, so speculation. They said that when they couldn't develop a profile from that microscopic DNA on the button snap of the knife sheath, they sent that DNA off to a private lab in Texas, which was like a startup, and that's what they're talking about here. So at least now we can see the name for it and everything in Texas. So apparently it happened. The U.S. Department of Justice issued its interim policy for forensic genealogical DNA analysis and search in 2019. The policy describes the process that law enforcement engages in during these searches and the results and limitations of the method. The identified individuals are one or more genetic associations. That means that the donor of the forensic or reference sample may be related to a service user. Emphasis added, which may require additional investigative work and testing. If a suspect is identified, the agency is required to retain, two, it says A and then I think two, FGG profiles, account information and data for potential use during prosecution and subsequent judicial proceedings. See attached Exhibit B. Then, a new collaborative, National Technology Validation and Implementation Collaborative, was established in 2022. Its purpose is to collaborate and formulate methods and policy for labs and law enforcement to establish forensic, investigative, genetic, genealogy programs. This collaborative contributed to a forensic science journal. The publication includes contributors from Idaho. And then they give a whole bunch of examples. This publication includes reference to the aforementioned U.S. Department of Justice interim policy. Of particular note is the policy of release of information in accordance with rules of discovery. See attached Exhibit C. I am aware of specific news reports in this case regarding Mr. Kohberger's DNA, as published by the New York Times on June 11, 2023, that FBI personnel worked with a profile that Othram had produced, spending days building out a family tree that began with distant relatives. The New York Times sources have more information than the state has disclosed to the defense. Oh dear. The New York Times article generated intense media coverage and interest, the scope of which is explained in the True Scope report attached as Exhibit D. In addition, Mr. Kohberger's defense team has discussed the use of statistics in this type of case with experts who have informed me that the manner of identifying Mr. Kohberger by this type of search may have significant impacts on the statistical analysis of the CODIS profile generated by the Idaho State Police Lab, without access to the actual genetic genealogy search methods and results. It's impossible for qualified experts to address these issues. Counsel for Mr. Kohberger notes that the state utilized a statistical analysis number to claim a high likelihood of a match between the DNA on the sheath and that of Mr. Kohberger. The state, by its own admission, has taken a number of steps to identify Mr. Kohberger as a match. The statistical probability is not an absolute. The size of comparison sample and the nature of the search are important to ascertain conclusion bias. Mr. Kohberger has a right to effective assistance of counsel. He has a right to confront evidence. Counsel must undertake a thorough investigation of all parts of the case the state brings against Mr. Kohberger. As such, the genetic genealogy investigation and process is necessary for the defense team to do its job. I declare under the penalty of perjury that the foregoing is true and correct, and all of that with a signature, right? So that's what we have there. Then they have Idaho State Police, Idaho Chief Sheriffs and prosecutors from ISP Forensic Services. Okay. And they say the Idaho State Police Forensic Services Lab is extremely excited to announce that we have secured a Bureau of Justice Assistance grant to fund genetic genealogy testing and searching of unsolved Idaho cases. The cases we are starting with are unsolved homicide, essay, and missing person or unidentified remains cases. Idaho is the first state in the country to take the statewide approach for this technology. Instead of each law enforcement agency having to negotiate their own contract, pricing, and quality control with a private lab and genealogist, ISPFS has done that at the state level through the Idaho Department of Purchasing. In addition, by ISPFS securing federal grant funding, we can offer these services to local, county, and state agencies at no cost to the local law enforcement agency. In order to facilitate this, ISPFS has informed a state genetic genealogy investigation team consisting of laboratory personnel, an Idaho State Police investigator, detective, and a representative from the Rocky Mountain Information Network to identify cases eligible for testing under this grant. Once a case is identified as eligible, the team is reaching out to the local law enforcement agency and prosecutor to bring them onto the team for that case. The state team is a resource for local law enforcement. Idaho now has a formal contract with Othram Laboratories, a prominent leader in forensic genealogy, to conduct the genealogy testing and forensic genealogy searching. ISPFS is ensuring that Othram follows accepted laboratory processes and procedures and complies with the United States DOJ interim policy on forensic, genetic, genealogy, DNA analysis and searching. ISPFS has already searched our records for cases we know would be eligible under this program. We've started contacting individual Idaho law enforcement entities and prosecutors on approximately 15 of those cases. The law enforcement entity and prosecuting attorney are being asked to confirm certain case criteria and sign an MOU that they will investigate this case if the molecular genealogy technique generates investigative leads, that they will follow DOJ policy for investigating these cases, and that they will take all appropriate prosecution actions as an outcome of the investigation. All very interesting, and I know that that's also brought about some theories that they're very excited about this and they wanted a case, to show off what they can do. I just don't know if they would toy with a case like that, but to each their own. You're entitled to your own theories. Let me know in the comments below what you think. They say, we want to be very clear that the local or county law enforcement agency will retain jurisdiction and responsibility for the case. The state team is in place to identify cases, coordinate with local entities, provide investigative resources if requested, safeguard that the molecular genealogy technology and techniques are being appropriately used in Idaho, and ensure that all necessary resources are reliable and available at no cost to local law enforcement for use of this technique. ISPFS is committed to ensuring that the lab science and genealogy work is robust, that the evidence is treated appropriately by the contract lab and in a way that allows for appropriate prosecution, and that the contract with a private lab and federal funding are spent appropriately. If more funding resources are needed to support this effort, ISPFS will obtain those resources in support of all Idaho law enforcement. ISPFS is also evaluating offering these services in Idaho if the need is demonstrated from this project. Seems like this case, the need was demonstrated, right? They had a big project on their hands then. We are accepting requests to work other cases that have not been identified by our team. If you have those cases, please reach out to our appointed project lead on this effort, Ms. Rylene Nolan. She can be reached at all cases accepted into this program are subject to an MOU. And then they say United States Department of Justice interim policy, forensic, genetic, genealogical, DNA analysis, and searching. Now this is a lot to read through. Look at it, the background, application. This document is available in the source that I've linked in the description box. If you don't want to go and download those documents yourself, I will put it on Patreon as well. That's where documents, I put them there too, if you are interested. So they're talking about how they work in this document, okay? If we were only reading this document, I would read through every single word, okay? But one, we've got to conserve my voice for the rest of the many pages we're going to read. And two, this is background of what they do, right? So they're talking about it. If you find it interesting as well, if you spot something interesting here, please let me know. But yes, I'm just showing you. I'm just going to go through it like this. They say investigative caution, which let's just read through this. They say investigative agencies shall identify themselves as law enforcement to GG services and enter and search FGG profiles only in those GG services that provide explicit notice to their service users and the public that law enforcement may use their service sites to investigate crimes or to identify unidentified human remains. The investigative agency shall, if possible, configure service site user settings that control access to the FGG profile, data, and associated account information in a manner that will prevent it from being viewed by other service users. Which is what I believe they were doing and explaining in the protective order, the state's motion for a protective order. So they're still going here, explaining everything. I'm not skipping completely over the document. I want to show you what they say here, right? And so here as well, what do they have here? Let's just quickly do this so that you can see it nicely. There we go. National Technology Validation and Implementation Collaborative Policies and Procedures for Forensic Investigative Genetic Genealogy. So, founding members. I'm sure this will all be a very interesting deep dive in another layer as well. Founding members of the NTVIC are the Idaho State Police Forensic Services and all these others as well. Okay, very interesting. Showing you what's happening here. It looks almost like, you know, when you sign up at the gym and they show you this huge contract and you're like, yeah, okay, where do I sign, right? Nevertheless, I'm showing it to you here. New York Times, here's the Mike Baker article when they say, inside the hunt for the University of Idaho killer, a new DNA technique finally brought a breakthrough. 14th of June, okay. Seattle Times, inside the hunt for an Idaho killer as well. And then they're just showing all the receipts. Everywhere this was published and saying, they know more than we do. Right, Yahoo News. Don't see any Grizzly true crime there, thank goodness. Let's hope that never happens unless it's in positive light, of course. So, yes, you can see it was shared everywhere, which also shows you when there's someone writing an article, damn, it gets shared everywhere and copied and recopied and all of that. So that is that document. Now we got to go to the next one, okay? This is the next one. And this one is a 4-page summary of what we just read, which says, defendant's motion, third motion to compel discovery, comes now Bryan C. Kohberger, by and through his attorney Ancy Taylor, public defender, and pursuant to Idaho Criminal Rule 16F, hereby moves the court to order the state to comply with the defendant's third supplemental request for discovery, filed herein on or about May 3rd, 2023. Oh, okay. May 3rd. That was a while ago, huh? Mr. Kohberger requests an order for the state to disclose the following items included in the defendant's third supplemental request for discovery. Now, this is what they've been asking for, okay? Standard lab discovery. 3. Profiles uploaded to a DNA database. In the event that the case involves the upload of a DNA profile to either a local, state, or national database, and they give all the examples there, please provide all documentation maintained by the testing laboratory, including documentation maintained by the combined DNA index system, CODIS, personnel within the lab, including profiles that have been identified as unknown males, not the defendant. So they're very busy with that as well. Of course, they need to defend their client, who is innocent till proven guilty, and they have before arrested people and even convicted them of crimes that they did not commit. We've seen it happen before. I'm not saying that's the case here. I'm saying, though, it is possible. It's not like it's never happened. So he is innocent till proven guilty in a court of law, and I think the defense is doing a very good job. What do you think? So they say documentation of all uploads, including interpretation and or deconvolutions of mixed profiles, handwritten notes, spreadsheets, match estimated results, upload forms, and CODIS search forms. For each hit, please provide match detail reports and long-form candidate match reports for the hits, including partial hits and hits that are dispositioned to be non-matching, even if the lab has dispositioned a profile as a hit. Any state manuals regarding the use of SDIS and NDIS database systems. Any hits made to any profile uploaded, even if they hit on individuals not the defendant and deemed to not be candidate matches, including hits to any unknown males identified via testing. The state has provided information related to this request for the DNA on the snap of the knife sheath only. The defense has requested all DNA profiles, including additional profiles developed during the course of law enforcement investigation. See declarations of counsel for Mr. Kohberger, Bicka, Barlo, and Steve Mercer, filed simultaneously. And we're going to look at that next. Communications. Please provide a copy of all communications between lab personnel and any other party with regard to biological testing in this case, including letters, memos, emails, texts, records of telephone conversations. They like bring the receipts, right? These materials should include communications with regard to outsourcing of DNA testing, statistical calculations, and DNA profiles uploaded to a database. All emails, text messages, electronic messages, and other messages have not been provided. See declarations of counsel for Mr. Kohberger, Bicka, Barlo, and Steve Mercer, filed simultaneously. Unexpected results and corrective actions. For each laboratory that performed DNA testing in this case, please provide copies of the laboratory's logs of unexpected results and corrective actions. The logs should be provided for the time period beginning 6 months before the start of the testing and ending 6 months after the completion of the testing. Documentation should be provided for unexpected result events that arose due to mechanical, chemical, and/or analyst operations, including contamination, the presence of extraneous DNA, sample handling errors, or any other reason. The logs should be provided for all laboratory personnel, not just the analyst who performed the testing in this case. Please note, this is a request for the logs themselves, not just for entries within the logs that pertain to this case. Unexpected results and corrective actions were requested for the 6 months before and 6 months after testing related to the case. Only entries relating to lab personnel in this case were provided. See declarations of counsel for Mr. Kohberger, Bicka, Barlo, and Steve Mercer filed simultaneously. Then, page 3 or 4 of this document, genetic genealogy testing and search. All reports generated by any lab that conducted SNP testing on any sample in this case, including from samples where unknown males, not the defendant, were identified. Copies of all communications between laboratory personnel and any other person or organization with regard to the instant case, including letters, memos, emails, internet posts, press releases, and records of other communications, including communications with regard to any DNA profile uploaded to any public or private DNA database. Take a deep breath here. Give me a thumbs up while you're at it. Cheer me on, guys. Cheer me on. Okay. All documentation associated with any database search, including but not limited to CODIS, NDIS, GED match, family tree DNA, and/or felon databases, case sample databases, missing persons databases, and internal quality assurance databases. The documentation should include, but is not limited to, the input profile, the input search parameters, the search output, all reports, all correspondence, and any follow-up actions. All documents related to any genetic genealogy search, including but not limited to the creation of a user profile, profiles, accounts, information, automated search results, uploading of data, all queries and search results from any private or public data banks, family tree information, and all other documents, reports, notes, or other communications pertaining to genealogy DNA database searches. All documents related to any genetic genealogy investigation, including but not limited to additional collection and/or testing of DNA samples, notes of any interviews, documents obtained related to ancestry, and/or recommendations for further testing. All documents related to the comparison of any DNA samples collected during the genealogy investigation to crime scene evidence. And 7, page 404 of this one, the name and address of all persons found to have sufficient sharing centimorgans with the subject profile to be identified as a match in the report created in this case. Are you still following? Okay. The state has objected to this discovery request. Further, the state has filed a motion for a protective order. Mr. Kohberger incorporates herein his objection to the state's motion for protective order, as well as declarations of counsel for Mr. Kohberger, Bicka, Barlo, and Steve Mercer in support of the defendant's motion to compel. The counsel requests that this motion be set for hearing in order to present oral argument, evidence, and/or testimony in support thereof. Requested time is 10, and they write in their brackets, 20 minutes. Okay, 20 minutes. Interesting. A hearing. I don't know if it's going to be 20 minutes. I'm sure it'll be longer than that, right? Hearing is happening tomorrow, in case you forgot or you're just joining now if you are watching this video later or whatever. If you've skipped forward, in the beginning, we talked about a hearing that's happening on June 27th, 2023, which is what they applied for here. Okay, so shall we move on to the next document? Now, this one is quite lengthy as well, but are we ready to dive in? State of Idaho Plaintiff versus Bryan C. Kohberger. Notice of filing declaration of Bicka, Barlo in support of defendant's third motion to compel. Comes now, Bryan C. Kohberger, Bryan 3's attorney of record, Ann C. Taylor, public defender, and hereby files the attached declaration of Bicka, Barlo in support of the defendant's third motion to compel. This was dated the 22nd of June, 2023. Okay, so we continue on. Declaration of Bicka, Barlo. I, Bicka, Barlo, do state and declare I'm an attorney licensed to practice law in the state of California, and I've been retained to assist counsel for Bryan Kohberger in the above matter in the capacity of DNA consultant. So they reached out to experts, Bryan Kohberger's defense, that like, can you help us? Can you help us know what the heck we're supposed to be asking for? How to poke holes in this case? And they brought it. So here we go. I have a BS from the University of California, Berkeley in genetics, and an MS from Cornell University in developmental genetics with minors in cellular biology and plant molecular biology. I received my JD from the University of San Francisco School of Law. I began consulting on DNA cases as a law student in 1994. In 2004, I was hired as the DNA attorney for the San Francisco Public Defender's Office. During my 9 years at the office, my practice was focused almost completely on DNA cases. In 2013, I left the office and returned to consulting on DNA cases throughout the United States in both state and federal courts and at all stages of litigation. I have acted as DNA counsel or as a consultant on cases involving DNA evidence in over 200 cases, including capital cases in both trial and post-conviction proceedings. Additionally, I've been retained in 3 cases as a Strickland expert to assess the performance of trial counsel as it related to the DNA evidence. As DNA counsel, I've reviewed case files for DNA evidence from many labs throughout California and the United States, including the California Department of Justice, SCRI, Forensic Analytical Board, Orchid, Cellmark, the FBI, the St. Charles MO Police Department Crime Lab, and a whole bunch of other places, as you can see. So many places. This is an expert, okay? I regularly communicate with attorneys and experts who specialize in DNA evidence. I also regularly train attorneys in the area of DNA evidence. I was requested by counsel in this case to assist in determining the scope of DNA discovery necessary for defending this case, including any genetic genealogy that was used. Part of this assignment was to identify potential expert witness and legal issues that might arise from the use of genetic genealogy in particular. Because I have been retained on other cases involving genetic genealogy, I am aware of the methods used and the type of material that is and has been made available in criminal cases. In order to assist counsel in this and other cases, I have reviewed a multitude of materials, including peer-reviewed articles, magazine and newspaper articles, and motions submitted in other cases. I have also interviewed numerous expert witnesses in order to identify potential areas of interest to the defense. You see? They're like, can you help us? What do we need to ask for? How do we poke holes in this case? He's like, do this, this, and this. Very good job on the defense's part, right? I've reviewed the material provided to the defense in this case regarding the DNA testing done, as well as numerous news articles regarding the case and the government's motion for protective order, filed on June 16th, 2023. That's the one we read through before. So again, if you didn't watch that, please go watch that video. I'm informed and believe via news reports that in this case, Mr. Kohberger was initially identified as a possible suspect via a new technology, via a new methodology called investigative or forensic genetic genealogy, hereinafter IgG. So, genealogy testing and database searches. I'm familiar with the methods used to conduct IgG searches in criminal cases. I've been retained in other jurisdictions on cases involving this type of search and have received and reviewed reports generated by the private company that conducted both the testing itself and the construction of the family tree that led to the identification of the defendant in those matters. Based on my review of that material, I'm informed and believe that the use of these databases does not necessarily lead to a single individual as a potential suspect. The testing conducted by the private lab is different in nature from the testing done by forensic labs. The private labs do not generate a profile in the same way that the forensic labs do, and there cannot be a direct comparison between the data obtained in this case by the Idaho State Police, the ISP lab, and the private lab. Two totally different things, right? The ISP lab had conducted what is typically called STR-based testing, which results in a profile that can be uploaded to the state and federal CODIS databases. IgG labs use a different technology where individual SNPs, single nucleotide polymorphisms, are sequenced. The SNP and STR data cannot be directly compared. Once the IgG lab completes its testing, the SMP data is uploaded to a genetic genealogy database that contains similar data from other individuals. One such database is GED Match. GED Match has recently been acquired by Verogen Labs. They got the link right there. I'm aware of only one other website that allows law enforcement searches. Most websites, such as 23andMe, do not allow use of their data by law enforcement and are used by most people for ancestry research. Data is compared within that database and possible relatives identified. The determination of who is or is not a relative is subjective and based on the length of DNA shared between two individuals. The comparisons in such a database do not yield an identification of someone identical to the uploaded SMP data. Rather, it would identify possible relatives who might be in the database. And yes, before you guys say it, they do mention the Golden State Killer in one of these documents later, either this one or the next one. We shall see, because it might remind you of that case, right? Once a putative relative has been identified, a family tree is created, working backwards to grandparents and possible great-great-grandparents. The family tree is then built down. The construction of these family trees is highly subjective and is based on the use of public records such as marriage and birth certificates. Difficulties with tracing a family tree may arise when there are events that sever a relationship, such as an out-of-wedlock birth, name change, or adoption. In some instances, contacting individuals for further family information such as noted above. This process leads to a pool of individuals rather than one specific individual. I'm also aware via news reports in the Golden State Killer case, there it is, that multiple individuals are often identified and must be eliminated in order to find the potential suspect. So I think what the defense is going for here is, did you do that? Did you eliminate every other family member in this pool that you found related to Bryan Kohberger, whether they were in Washington or not at the time? That'll be interesting, because that'll be a very good hole to poke in this case, right? So then they say, as described in the Washington Post, the technique leads to a pool of relatives, not to a single individual. The same issue has come up in other cases where more than one individual was identified and subject to investigation. In the episode of the genetic detective show Who Killed Andy Dodge, last visitor, then at least one relative of the defendant in that case was investigated and ruled out. Further complicating the Dodge case was the fact that the defendant in that case had been born after his parents' divorce and adopted by his stepfather. In addition, there's been a history of misuse of these IgG databases by law enforcement. Abuses by law enforcement of the GED match resulted in users opting out of the use of their DNA data by law enforcement. The abuses and protests by users led GED match to change their database so that users had to opt in for law enforcement use. Tell me, would you opt in or no? Because I so would. Yes, I would opt in. You know, if any DNA that I submit to these databases can help catch a killer, even if they are some distant relative or something, yes, do it. Catch them. Catch all of them. But let me know what you think. Some people are like, oh, hell no. They will not allow that. So I'd love to hear your thoughts in the comments below. So there they say, family tree DNA, right? Okay, we were there. Automatically opts users into law enforcement searches. An example of other abuses of this technology, a Florida police officer obtained a warrant for the entire GED match database, despite users' choice to opt out of law enforcement searches. Recently, the state of Maryland passed a statute regulating the use of IgG searches, requiring court approval at many stages of the process. They give an example there. I'm going to, for now, just skip over that so we can carry on. Okay, you can pause and read that if you want to. In some cases, both law enforcement and the genealogists that they have employed have engaged in deceptive practices, tricking family members, surreptitiously gathering genetic material from non-suspect family members, or simply uploading an evidentiary profile to a database that does not allow law enforcement searches. It's imperative to the defense in this case to know how Mr. Kohberger was identified and who else in his family tree might have been identified as a subject of investigation. While in the Dodge case, another relative was ruled out, it's unknown to the defense in this case, whether every lead or possible suspect was further investigated and ruled out by genetic testing. Because the family trees generated by these genealogy searches often identify distant relatives through great or great-great-grandparents, a person may be completely unaware of the relatives in the genetic genealogy searches and unable to conduct an independent investigation of possible third-party suspects. It's not possible for any defendant to investigate family relatives who are unknown to him and may in fact have been in the area of the crime. I say that because, like, damn, imagine if it's like some distant relative. A fourth cousin has arrived on the scene. Very unlikely, but is it possible? Maybe. Let me know what you think. So this material clearly is Brady material in that it would provide investigative leads that are otherwise unavailable to Mr. Kohberger. IgG cases and similarities to CODIS DNA database searches. In my opinion, as an attorney who specializes in DNA cases and who has seen both cold hit cases and IgG cases, the IgG database search results raise the same type of questions and areas of investigation that a cold hit case would. First, as noted above, who else was included in the pool of putative relatives in the first instance of the IgG database? Second, once the IgG search was completed, who in the pool of identified putative suspects were ruled out by further investigation? For the defense team, how many others were investigated and what caused law enforcement to focus on Mr. Kohberger is key to possible investigation and third-party suspects. Third, and in many ways most importantly, how does the search of a large database impact the statistical analysis of the comparison by the state lab using STR methods? As with cold hit cases, it is now well recognized that the statistical analysis of a comparison of standard STR profiles is impacted by a phenomenon called ascertainment bias. In the case of cold hits, initially, courts did not allow the fact of a cold hit as well as its associated statistical, the database match probability, DMP, as evidence for reasons similar to those presented by the government in this case. Aaron Murphy, Inside the Cell, 2015. See attachment 2. However, it is now accepted that in a cold hit case, the DMP is generally accepted and can be calculated by crime labs. The best illustration of this can be found in US versus Jenkins. So there they say the database match probability accurately expresses the probability of obtaining a cold hit from a search of a particular database. And again, examples, right? The government cites to a California trial court order in Michael Green. They mentioned that case before. Remember, we looked at that before. I think it was from the state's motion to the protection order. Okay, so they say, which relies heavily on People versus Johnson as support for the proposition that the IgG material need not be disclosed. In its argument that the IgG search is a mere tip and not subject to discovery by the defense, the prosecution misreads Johnson. The issue in Johnson was when the government seeks to admit the fact of the cold hit, should the court require the government to also present the DMP described above rather than the standard RMP statistic. In fact, in Johnson, the fact of the cold hit was admitted over the defendant's objection. In People versus Turner, 2020, the California Supreme Court confirmed that the DMP statistic in a case in which a defendant is identified via cold hit is relevant and admissible, and that there is no controversy in the relevant scientific community as to the accuracy of the various formulas. In other words, the math that underlies the calculations is not being questioned. Each approach to expressing significance of a cold hit DNA match accurately answers the question it seeks to address. The rarity statistic accurately expresses how rare a genetic profile is in a given society. Database match probability accurately expresses the probability of obtaining a cold hit from a search of a particular database. Bayesian analysis accurately expresses the probability that the person identified through the cold hit is the actual source of the DNA in light of the fact that a known quantity of potential suspects was eliminated through the database search. So that's pretty important, I guess, once you have the pool narrowed down to eliminate whoever's in the pool. And maybe they did do that, but that's what the defense wants to see. I've spoken with a number of experts in the field who've expressed the opinion that an IgG search can impact the statistical rarity of a profile in a manner similar to a cold hit search, meaning that the statistic that is generated by an analysis of an IgG search could yield a relevant and admissible statistic. In the case of a cold hit case, even a high RMP can yield a low DMP statistic inside the cell. Okay, for instance, an RMP of 1 in 1 million can yield a DMP of 1 in 3, which means that while the profile is rare, the likelihood of getting a coincidental match during the search of the database and selecting a person who matches but is not the perpetrator is high. When this evidence is excluded, jurors wonder why and how the defendant was identified. I mean, at this point, of course, the public wonders how and why was Kohberger identified. So obviously we can imagine the jury would be like, why? How did they get to him? The Elantra, the everything? How do we know it's not the DoorDash driver? Is he the DoorDash driver? How do we know what kind of car Bryan Kohberger had? What about that other white Elantra that crashed in Oregon, huh? What happened to that? And the Moscow, Idaho slip that was inside the, what we call in South Africa, cubby hole. I don't know what you call it in America. That little dashboard cubby, you know? Anyway, we call it a cubby hole. So remember that whole thing. There's so many questions, of course, still in this case. And I really hope that at the trial, which is going to be like, I think it's going to be the highest profile trial in a long time, don't you think? And yes, we'll be covering it here on Grizzly True Crime. Of course we will. As much as we can, and we hope there'll be cameras. That's why I say that, because you just never know if they'll be like, that's it. No cameras, no audio, no public will be like, what? But let's see what happens. So, to continue on, let's not waffle too much there. Sorry about that. They say, when this evidence is excluded, jurors wonder why and how the defendant was identified. In one case, where the evidence of the search and the DMP was excluded, jurors inquired of the trial court how he'd been identified. Failing to allow the defense access to the ability to investigate and potentially present evidence about the tip that the government intends to exclude could lead a jury being actively misled by the strength of the government's evidence as it relates to the DNA on the sheath. The government's arguments are similar to those that were eventually discarded by the courts when they recognized that the search of a database can be considered as relevant evidence. Research in the area of the impact of an IgG search on the statistical weight of a DNA comparison using standard STR DNA profiles is ongoing. The ascertainment bias is accounted for using CODIS and standard STR testing by use of the DMP statistic. The DMP helps a jury understand the likely of a coincidental match when a database is searched, which is different than the simple rarity of the profile expressed with an RMP. Without access to the results of the search, including how the first putative relative was identified, how many profiles were in the databases searched, which databases were searched, and how the family tree was constructed along with the family tree itself, Mr. Kohberger has no means to address possible significant issues with the government's evidence. Item 4.2, match detail reports and long-form candidate match reports for the hits, including partial hits and hits that are dispositioned to be non-matching, even if the laboratory has dispositioned a profile as a hit. From the discovery in this case, now this is interesting, pay attention, don't get bored now, are you alert? Hydration check, coffee check, okay, I'm good. From the discovery in this case, it appears that at least 3, and possibly 4, profiles were uploaded to the CODIS database prior to Mr. Kohberger being charged. Well, that's interesting. That's not just like 3 random dudes' DNA in the room. Oh no, here they're saying, from the discovery in this case, it appears that 3, and possibly 4 profiles were uploaded. So they'd narrowed it down to those and uploaded to the CODIS database, right? Prior to Mr. Kohberger being charged. Mr. Kohberger has requested the discovery of these uploads and any resulting hits or candidate matches to these unknown male profile, even if the lab has dispositioned them as non-candidate matches. When a profile is uploaded to the CODIS database, it is searched continuously against the database of convicted offenders and arrestees maintained by the state, generally on a weekly basis. This ensures that as new individuals are added to the database, they will hit on evidence sample profiles if they are deemed a match. These candidates are then forwarded directly to the lab that uploaded the evidence profile for further evaluation. The lab will then determine if the individual candidate is a candidate match or non-match. The lab then dispositions the individual in the database as a candidate match or non-match. All that the lab sees of the candidates is an anonymized DNA profile. The disposition of a candidate match triggers the state to then provide the identity of that individual to the lab for further investigation. In the last 10 years of my practice, I've encountered a number of cases in which a database search has resulted in more than one candidate, and in which, upon court order, the anonymous profiles of the other non-matching profiles have been provided to the defense under court order. The number of non-matching profiles varies from case to case and include one case in Santa Clara County, People versus George Shirakawa, case number, and one case in San Francisco County, People versus Hernandez, case number. The Hernandez case is illustrative of the subjective nature of the interpretation. In Hernandez, the lab uploaded multiple interpretations of a mixed sample to the state database. One interpretation returned 5 candidates, and the second returned 28 candidates, including the defendant. In Hernandez, the lab opined that 2 of the candidates could not be excluded as a source, while a defense expert reached a different opinion that 15 of the candidates could not be excluded. The lab in the Hernandez case provided to the defendant the profiles of the 5 and 28 individuals from the CODIS search. This information was presented at trial in order to impeach the interpretation of the work done by the lab and to undermine the idea that a match by a lab is an actual identification of a single individual. Oh, okay. Very interesting. The fact of this match made by the CODIS system is considered Brady material because it provides possible avenues of investigation of other suspects in the case. Given the subjective nature of mixture interpretation, it is reasonable to believe that other experts might disagree with whom actually is the candidate. And in this case, in which the profile at issue is ambiguous and partial, other suspects are an important area of investigation. I agree. Item 11. Unexpected results and corrective actions. Laboratories are required under accreditation standards to maintain logs of what are called corrective actions or unexpected results, along with root cause analysis documents for specific types of incidents encountered in labs. These logs are an important measure of how the test methods are performing in the lab and also can be an indication of ongoing systemic issues as well as analyst-specific issues, both of which may be relevant to the testing in this case. The San Francisco Crime Lab routinely produces the entire log to the Office of the District Attorney as Brady material, and this document is distributed to the defense bar. The last iteration of this document was over 100 pages. I declare under penalty of perjury that the foregoing is true and correct, and that those matters stated upon information and belief are true, to the best of my knowledge. And that's signed. Now, the rest of this document, this is page 16, this is page 15 of 39. The rest of the document are Bicka Barlo's credentials, okay? It's literally, look at it. I'm just showing it to you. Damn, a lot of credentials we got going on here. So let's just zoom through like this. You see? You see that? And then they go inside the cell, the dark side of forensic DNA. Sounds very interesting, in fact. Let me know if you've ever read that. And they've uploaded scans of this book. And, citing their sources and references made. So that's that document. Now, the next one is this one. This one's 11 pages. We're almost there, everyone. We're in the final stretch. We've got this one and then the document that's been going around on the internet. That one, I think, is 8 pages or so. And then we're done. Okay? Almost an hour in. Are you okay? I'm okay, let's go. Okay, in the District Court of the 2nd Judicial District of the State of Idaho, in and for the County of Latah. Don't ask me why I wasted my voice on that sentence. State of Idaho Plaintiff versus Bryan Kohberger. Notice of filing declaration of Stephen B. Mercer in support of the defendant's third motion to compel. Another expert is what we have here. Comes now, Bryan Kohberger, by and through his attorney of record, Ann C. Taylor, public defender, hereby files the attached declaration of Stephen B. Mercer in support of the defendant's third motion to compel. Date on the 22nd of June, 2023. All right. Declaration of Stephen B. Mercer. The defense has retained me to determine what a reasonably competent criminal defense attorney would do to adequately investigate and understand the DNA evidence, including forensic, genetic, genealogical DNA analysis and search, FGGS, also referred to as investigative genetic genealogy, IGG, when representing a defendant in a criminal case. I have based my opinions on my training and experience as the former chief attorney of the forensic division at Maryland's office of the public defender. Like, damn, lots of experience that they've called on here, right? To be like, can you help us? Which again, I'll say they're doing a good job, right? And the director of its statewide litigation support group, and my professional and litigation experience as a legal practitioner, including casework in 2 FGGS or IGG matters. I have included my resume with this declaration. To summarize, for much of my 28 years practicing law, I've been actively involved in litigation, training, and commentary related to issues arising at the intersection of DNA technology and the law. In 2003, I litigated the first constitutional challenge to Maryland's DNA data bank. I later led the successful effort before the Maryland General Assembly and the DC Council to ban familial searching of DNA databanks. That litigation led to DNA training and opportunities to work closely with expert DNA scientists and tour forensic DNA laboratories. By 2005, I began collaborating with Maryland's Office of the Public Defender's OPD Forensics Division on post-conviction DNA innocence cases and assisted with OPD's DNA college training for assistant public defenders. In 2010, the public defender recruited me to become the chief attorney of OPD's Forensics Division. So you get the gist? Highly qualified individual. Okay, you could see everything here. If you want to pause to read, please do that. But expert. Okay, so we continue on. Still, expert of evidence testing. Okay, we got all that. And this is a brief one. Let me just give you a brief summary here of what I've done. Like, oh my word. Okay. So, to continue on. Sorry, I actually want to go up a little bit. Wait. So they say I was responsible for this and this. Yes. So let's just read from here. To that end, I developed and published internally at OPD a manual that articulated when an attorney should request expert services. At a minimum, an attorney should request expert services when there is a reasonable probability, 1, that an expert would be of material assistance to the defense, which I think in this case, yes. 2, that denial of expert assistance would result in a fundamentally unfair trial. Assistance includes preparing defense counsel to effectively investigate a case, obtain discovery, negotiate a plea, challenge the admissibility of evidence, cross-examine the prosecution's experts, and present defense evidence and expert testimony. This standard does not require a prima facie showing of what counsel intends to prove at trial, nor must the factual basis for the defense's expert's opinion be undisputed. Still, there must be more than undeveloped assertions that the requested assistance would be helpful. In summary, counsel for a client may need to make a detailed, although not conclusive, showing to justify the retention of an expert. It is a minimum practice standard for defense counsel's investigation to obtain discovery of DNA testing of evidence regardless of the prosecuting authority's decision to offer the DNA testing results as evidence at a hearing or trial. One more time. It's a minimum practice standard for the defense's counsel, their investigation, to obtain discovery of DNA testing of evidence regardless of the prosecuting authority's decision to offer the DNA testing results as evidence at a hearing or trial. The minimum practice standard for investigating DNA evidence is rooted in the ABA Standards for Criminal Justice, Defense Function Standard 44, which outlines the general responsibilities of a criminal defendant's trial counsel regarding the duty to investigate. So they got to do their job, right? It states defense counsel should conduct a prompt investigation of the circumstances of the case and explore all avenues leading to facts relevant to the merits of the case and the penalty in the event of conviction. The investigation should include efforts to secure information in the possession of the prosecution and law enforcement authorities. The duty to investigate exists regardless of the accused's admission or statements to the defense counsel of facts constituting guilt of the accused's stated desire to plead guilty, which he has not indicated that. He's in fact stood silent which was an automatic not guilty plea. Remember that. Okay, so then they say ABA standard for criminal justice defense function. Relatedly, the ABA has promulgated a set of criminal justice standards on DNA evidence in 2007 that requires the pre-trial production of DNA discovery. Standard 4.1 disclosure provides A. The prosecutor should be required within a specified and reasonable time prior to the trial to make available to the defense the following information and material relating to DNA evidence. Now I'm reading this to you because, prosecution, what you got? You got all this? I really hope so. Otherwise they're like, oh crap, like there's a lot you have to hand over here. So they say, 1. Lab reports as provided in Standard 3.3. If different from or not contained in any lab report, a written description of the substance of the proposed testimony of each expert, the expert's opinion, and the underlying basis of that opinion. The lab case file and case notes, a CV for each testifying expert and for each person involved in the testing, the written material specified in Standard 3.1, reports of all proficiency examinations of each testifying expert and each person involved in the testing, with further information on proficiency testing discoverable on a showing of particularized need, the chain of custody, documents specified in Standard 2.5, all raw electronic data produced during testing, reports of lab contamination and other lab problems affecting testing procedures or results relevant to the evaluation of the procedures and test results obtained in the case and corrective actions taken in response, and a list of collected items that there is reason to believe contain DNA evidence but have been destroyed or lost or have otherwise become unavailable. Material or information within the prosecutor's possession or control, including lab information or material that would tend to negate the guilt of the defendant or reduce the punishment of the defendant. Okay, ABA Criminal Justice Standards, DNA Evidence, Standard 4.1 Disclosure. 7. The minimum practice standard for a competent defense counsel to obtain and review discovery applies to forensic, genetic, genealogical DNA analysis and search, FGGS, and investigative genetic genealogy, IGG. FGGS, or IGG, involves testing biological identification evidence from the crime scene or a targeted person to develop a genomic DNA profile and searching the results in a private ancestry or databases. The lab ranks the search results by centimorgan. Hope I'm saying that right. C capital M. Centimorgan is a unit of genetic measurement that describes how much DNA and the length of specific segments of DNA are shared between a GED DNA profile in the database and the GED DNA profile from the crime scene evidence or a targeted person of interest. FGGS or IGG involves a genealogical investigation by law enforcement based on the ranked matches found in the database searches to clarify the family tree of interest and potentially identify the branch populated by the source of the crime scene DNA evidence. Are you still nerding with me or what? Let me know. I find this all very interesting still. Okay. The scope of discovery provided by the prosecution in the FGGS or IGG cases I have worked on included kinship assessments from searches of genealogical databases and law enforcement's genealogical investigator findings to clarify a family tree and further target persons of interest. The discovery included information about law enforcement's genealogical investigations of the top ranked matches and persons of interest targeted for DNA sampling or further investigation. The discovery also included sample description information, chain of custody information, amplification, fragmentation, and precipitation details, hybridization information, DNA input levels, and consumption of sample details. The prosecuting authorities provided the discovery upon my request. 9. In general, the FGGS or IGG discovery is essential to the defense because, among other reasons, the discovery A includes the results of DNA testing of crime scene evidence. B, provides match information from database searches and potential suspect information from law enforcement's genealogical investigation. C, may identify the branch or branches of the family tree of interest that are consistent with the amount of DNA shared between the source of the crime scene DNA and the known persons in the database. D, identifies the public and private DNA databases searched by law enforcement and the ranking of the results. E, reveals the number of third parties who law enforcement may have targeted for covert, consensual, or warrant-based DNA collection. F, may identify the number of putative perpetrators identified through FGGS or IgG. And G, reveal whether law enforcement collected DNA samples from every putative perpetrator. H, may describe the manner in which law enforcement collected DNA samples from targeted individuals. And I, is necessary for the defense to be able to identify and consult with an expert. Therefore, under the minimum standards of practice for defense counsel investigating forensic DNA evidence, it's crucial for a reasonably competent attorney to obtain the FGGS and IgG discovery. 10. I reserve the opportunity to update my opinions based on new information. Good disclaimer they got there. And then the usual signature with a nice signature there, Stephen Mercer, okay? And then here are Mr. Mercer's qualifications, as you said. The resume is here. Okay, and finally, we are on this last document. This is the one that everyone's been reading on YouTube, going over, and I understand. I get it. I just wanted to read all of that other stuff first because that's what led to this, which I think is important to understand the whole thing, okay? Like how did they get to this? And why are they saying this? So here they say objection to the state's motion for protective order. Remember, if you have not seen me read through the state's motion for protective order, go check that out because it will give some context for this. Okay, so here they say, comes now Bryan C. Kohberger, Bryan through his attorney, J. Weston Logsdon, Chief Deputy Litigation, and hereby objects to the state's motion for protective order filed June 16th, 2023, on the grounds that the material the state seeks to hide is discoverable and must be provided to Mr. Kohberger. From everything we've just gone over, would you agree? Because it seems so to me. Yes, it's discoverable. Okay, so give us the receipts, right? Factual background. On November 13, 2022, law enforcement responding to a 911 call found Madison Mogan, Kaylee Consalves, Xana Kernodle, and Ethan Chapin deceased. Law enforcement later found a K-bar knife sheath placed next to Miss Mogan on her bed. The sheath, now they gave a lot of more details here, was placed button side down and partially under Miss Mogan and the comforter. On November 20th, 2022, the Idaho State Police Lab in Meridian, Idaho located DNA on the button, they previously said button snap, but okay, on the button of the sheath and performed STR analysis that led nowhere when ran through coders. This we know as well, right? So they didn't find any matches there. Combined DNA index system, other than to show the provider was a male. By December 17th, 2022, lab analysts were aware of 2 additional males' DNA within the house where the deceased were located and another unknown male DNA on a glove found outside the residence on November 20th, 2022. Interesting. November 20th. I think a lot of us were speculating on Twitter. I was thinking, a lot of us, me included, that could have been the glove found by Chris McDonough from the interview room. But I think he was there later. Wasn't he there like in January, Feb or something? I don't know. November 20th, that's just a week later. So that's interesting. But anyway, so okay, to this date, the defense is unaware of what sort of testing, if any, was conducted on these samples other than the STR DNA profiles. Further, these 3 separate and distinct male DNA profiles were not identified through coders, leading to the conclusion that the profiles do not belong to Mr. Kohberger. While this was ongoing, police were investigating many various possible suspects. Many of them provided DNA. At least one had his DNA surreptitiously taken from a discarded cigarette. Well, that's interesting, because does that mean that, okay, wait. So many of them, many various possible suspects, many provided DNA. Remember, there was also the neighbor, another guy with a J, right? Wasn't it Jeremy? The neighbor was like, I went in there and I provided my DNA, because people online were suspecting him after he'd done a lot of interviews. Remember that? There's a couple of neighbors. There's Inan and there's Jeremy, I think his name was, and there's a few of them. But anyway, so somebody, at least one, had his DNA surreptitiously taken from a discarded cigarette, which means they were probably being watched, right? Interesting. Many also had their phones taken and downloaded. Ooh, the things that must be on all those phones. One area of the investigation had to do with a white sedan seen on camera located at 1112 King Road. Just hold on, because it's 1122 King Road. So 1112 King Road. So the neighbors, right? Okay, the neighbors. One area of investigation had to do with a white sedan seen on camera. Yes, at the neighbor's house. First glimpsed by officers on November 18th, 2022. So 5 days later. Okay, by November 25th, 2022, police believed the car to be a white Elantra and asked law enforcement to be on the lookout for one. Precisely how the police came to believe the car was an Elantra is still unknown. Right, there's a lot of cars with the same shape and all that, and also they said a 2013 to 2015, right? 2011 to 2013. They botched the date of the Elantra. Yes, okay. You could see, now we're getting to the place where we're like, it's a marathon now, all these documents. Okay, so moving on. So they were like, precisely how the police came to believe the car was an Elantra is still unknown. A report from an analyst for the FBI, dated March 21st, 2023, shows the analyst heavily relying on a video of a car heading in the wrong direction at the wrong time on Ridge Road. Now, if you haven't seen all the roads, we've done some map time. We've even flown over the place. Mr. Grizzly, who's my husband, Raphael, he even did a whole flight simulation flyby of the area. So, but yeah, I'm probably going to deep dive this after this, honestly. I'm probably going to go and do some map time of my own and be like, yes, now where was this exactly? Okay, so continuing on. The state's latest filing admits that somewhere within all of this, they engaged in investigative genetic genealogy using the DNA taken from the button on the sheath, and now claims that it was due to the use of this technique that it tipped local law enforcement to investigate Mr. Kohberger. Okay, so based on the microscopic DNA found on the button snap of the knife sheath, and they've never found the weapon, okay, but the knife sheath, they then did this IgG testing, and then tipped police off that could be a Mr. Kohberger, and then they saw he drove a white Elantra. Okay, it remains unclear what the police first relied on in focusing their investigation on Mr. Kohberger. No matter what came first, the car or the genetic genealogy, the investigation has provided precious little. I like the way they word that. The investigation has provided precious little. There's no connection between Mr. Kohberger and the victims. There's no explanation for the total lack of DNA evidence from the victims in Mr. Kohberger's apartment, office, home, or vehicle. That has got everybody's jaws on the floor on the internet right now. It's just like, what? Because, of course, if they say there is no explanation, I mean, the obvious explanation will be like, He cleaned a lot. This guy cleaned. I mean, he was putting his freaking trash in little Ziploc baggies when they caught him, right, at his parents' house. This guy was cleaning for weeks before he was arrested. November 13, 2022 is when the crime happened, and he was arrested on December 30th in Pennsylvania. So the amount of cleaning he could have done would have been possibly an explanation, but I'm going to say the defense worded this very well and said there's no explanation for the total lack of DNA evidence. I mean, is there no explanation, or is it a clever way of wording it to make everybody doubt all of this now? I don't know. Let me know what you think. I personally think that this guy, he was a PhD student in criminal justice. He studied under Professor Ramsland, if you missed all of those episodes where we deep dive that, and who was very close to BTK, right? So if he in any way wanted to commit the perfect crime, let's say, again, he's innocent or proven guilty in a court of law, we know this. The point is, if he in any way, if Mr. Kohberger in any way, the PhD criminal justice student, who so badly wanted to intern at the police, and they turned him down, and the rumor is that they instead, 3 women got the job, or 2 women got the job, or something, that could just tick him off even more, if he was ticked off already, based on how women say he was treating them when he was a teaching assistant, and all of that, right? So, I'm getting to the point. The point is, if he was fantasizing about committing the perfect crime, I mean, he just probably would have covered as many bases as possible. I really wonder about that button snap DNA. And maybe he's like, if he said, because the media reported that he said, I'm eager to be exonerated. And the media reported, and I mean mainstream media, that he said, was anyone else arrested? Well, that's interesting, given that these other unknown DNA profiles, or there was anyone else arrested, if he said that. If he in fact said that. We don't know it as fact. We know that that's what was reported. The point is, man, this guy, he could have dextered himself up. He could have had 2 outfits and 2 pairs of shoes. He could have had a duffel bag. He could have, I don't know, done so much. Now, is it still highly unlikely that not a single drop of evidence would be in his car, especially in his car, right? Car, home, vehicle, whatever, all of that stuff. Sure, but there's so many factors that can still go into this. Especially if we go take a sharp left to Crazy Town, as I call it, which I don't mind going to here and there, and being like, whoa, what if there were 2 white Elantras? Or what if he, I don't know, Ubered that night or something? I'm sure they would have evidence of that by now. But you know what I mean. Is the evidence elsewhere? I mean, they sure as hell didn't find anything that we know of in his office, home, apartment, or vehicle. But could he have covered the whole damn car in plastic, for instance? Sure, could have. Could he have bleached everything? Sure, he could have. But now, see, do they have to say here that the entire car smelled like a bleach bomb? No, not really. At this point, not really. I'm sure we're going to learn so much from this trial, my word. Either way, there's a lot to unpack here. Honestly, there's a lot to think about. And yes, it does sometimes keep me up at night. I think about a lot of things, and I'm sure all of us do. I just do my level best to be so patient, waiting for this trial, okay? And there's gonna be those trolls or whatever. I just say trolls. I know you're not really trolls if you are those people, but like, why are you still talking about this? Just wait for the trial. Trust me, we're all waiting for the trial. But some of these things like this are important along the way, and I think we can learn a lot from it, right? From how the whole process works and what happens and what holes they're poking in the case, and being like, damn, imagine it. Imagine if this guy walks. It'll be like such a shock, and also not at the same time, which is why this case is extremely interesting. So moving on, they say in essence, through the lack of disclosure of their motion to protect the genealogy investigation, the state is hiding its entire case. Okay, so the state, you gotta bring the receipts. Argument. The state apparently thinks that they need not explain how they came to think that it was Mr. Kohberger's DNA on the sheath. Presumably, the defense is expected to accept at face value that the sheath had touched DNA, just waiting for testing by all the FBI's myriad resources. Additionally, the defense is to guess whether the state focused its investigation on Mr. Kohberger via a bizarrely complex DNA tree experiment or through its faulty identification of the vehicle involved in this case. Yes, perhaps unsurprisingly, Mr. Kohberger does not accept that his defense does not need this information. It rather obviously falls within the ambit of Rule 16b 4 and 5, a fact the state's briefing makes clear in its kitchen sink approach to their briefing. Can you feel the snark? There's a little bit of snark here and there, right? Precious little. And this whole, the fact that the state's briefing makes clear in its kitchen sink approach to their briefing. The state begins their argument claiming that Rule 16 has no interest in IgG testing, and then ends the argument claiming that somehow people will stop sharing their genetics if they were to realize the government's watching. Both arguments must fail. To begin with, the state apparently only wants to prevent Mr. Kohberger from seeing how the IgG profile is created and how many other people the FBI chose to ignore during the investigation. In essence, the state argues that if the later STR testing is accurate, then there's no reason to concern ourselves with how the state came to investigate Mr. Kohberger. Okay, they're making some valid points, right? State's brief at 9. What the state's argument asks this court and Mr. Kohberger is to assume that the DNA on the sheath was placed there by Mr. Kohberger and not someone else during an investigation that spans hundreds of members of law enforcement and apparently at least one lab the state refuses to name. Perhaps the most puzzling is the state's argument that while Rule 16b-5 requires them to turn over the results or reports from scientific investigations, it does not require the state to disclose what law enforcement does with the results or reports. State's brief at 14. First of all, that sounds like an admission that the information as to how the IgG was carried out should be disclosed. Second, what law enforcement does with results or reports is covered by Rule 16b-6, statements of prosecution witnesses, and 8, police reports. Frankly, the fact that members of the FBI are so concerned about permitting Mr. Kohberger to know what they were up to with was supposedly his DNA does not give one the impression that there is nothing to see here, as the state seems to imply. Finally, the state's claim that ICR 16G2 applies to this matter is quite bizarre. Presumably, the independent company the government relied on was paid for its work and would stand by it in a court. The state provides no real argument as to why the company needs to be protected. Mr. Kohberger is left to suspect that they wish to keep their methods from being questioned, to the extent that there is some concern about intellectual property that can be addressed via a protective order that permits Mr. Kohberger and his defense team to review their work. See State versus Pickett. Second, the state appears to argue that everyone living on Earth that provides genetic information is A, unaware that their DNA could be used by a government somewhere for something, and B, is an informant within the meaning of the term in the rule. The state citations to cases involving actual informants hardly help it make this incredible leap. No court has ever found the existence of a DNA informant. It would appear that the state is acknowledging that the companies are providing personal information to the state, and that those companies and the government would suffer if the public were to realize it. The only two databases that allow access are ones that already inform their users, and those users can opt in to allow law enforcement searches. The statement by the government implies that the databases searched may be ones that law enforcement is specifically barred from, which explains why they do not want to disclose their methods. That's going to be problematic if they went that way. If the fact that the government is looking at the genetic information that people are sharing was an all issue, then the state's very public acknowledgement of such investigations was clearly a big mistake. In any case, it's hard to understand why Mr. Kohberger should be the one to suffer, because these companies and our government choose to either mislead or not educate the public. According to the Pew Research Center, in February 2020, 48% of respondents thought it was acceptable to give their data to law enforcement to solve crime. 33% said no, and 18% were unsure. James Halpin, police use of forensic genealogy tech raises privacy concerns. The Citizen's Voice, March 28, 2022. However, 60% thought their genetic information could not be shared with other companies. There's no federal law about the sharing of genetic information, but multiple states have begun regulating police use. They give some examples there as well. Mr. Kohberger has reasons to be extremely suspicious of the IgG used in this case. Rather than seeing it as some sort of complex tree building that led to him, it appears far more like a lineup where the government was already aware of who they wanted to target. Rather than have the investigation done by someone blind to the fact, the FBI chose to do it themselves. This is akin to the police pulling in Mr. Kohberger and 5 of his cousins off the street and then pointing at him. The only authority the state has in its favor that is on point is a trial court order from a Californian case that settled before it could lead anywhere. That decision relied on its People versus Johnson. The court in Johnson was not deciding whether a defendant had a right to know how he was identified, only that his identification could come in a trial without a mini trial about it. We're almost there, you guys. 2 more pages. A better case on the issue, State versus Arteaga. In this case, an appellate court heard similar arguments about the need for software used for facial recognition to be discovered to the defendant, though they would not be admitted at trial. The court, considering the matter, found, and there... Wait, let's just see. Okay, we'll read through it. We are keenly aware the cases we've discussed involved instances concerning FRI hearings and potential expert testimony, and that here we are dealing instead with eyewitnesses who have already identified the perpetrator and the identification found admissible under Wade. However, the facts of this case convince us the defendant will be deprived of due process if he does not have access to the raw materials integral to the building of an effective defense. Okay, my voice is still hanging in there, and we've got an entire trial to cover later, whenever you're watching this. The evidence sought here is directly tied to the defense's ability to test the reliability of the FRT. As such, it's vital to impeach the witnesses. This is now an example, right? The witnesses' identification, challenge the state's investigation, create reasonable doubt, and demonstrate third-party guilt. The FRT's reliability has obvious implications for the accuracy of the identification process because an array constructed around a mistaken potential match would leave the witness with no actual perpetrator to choose. The reliability of the technology bears direct relevance to the quality and thoroughness of the broader criminal investigation and whether the potential matches the software returned yielded any other viable alternative suspects to establish third-party guilt. Defendant's request for the identity, design, specifications, and operation of the program or programs used for analysis and the database or databases used for comparison are relevant to FRT's reliability. At trial, the state will likely have the investigating officer explain the police investigation, including the process of retrieving the still photo from the surveillance cameras ultimately used to generate an image of the defendant. Although we do not speculate regarding the exact nature of this testimony and whether the defendant will seek to impeach it, the fact that the state does not bear the burden of abducing testimony regarding the composition of the photo array does not bar the defense access to the discovery sought. Mr. Kohberger finds himself in a similar position as Mr. Arteaga. A massive investigation came to focus on him and him alone. The state appears to be trying to hide its original domino such that he cannot discover why. Mr. Kohberger has a right to discover and question the investigation that led to him. This court should so find. Oh yes, we made it, you guys. We made it. Okay, so we've read through all the latest documents that we have so far before the hearing tomorrow. And now you know why that hearing is going to be very interesting, in my opinion. June 27th, 2023 at 1:30 p.m. There's going to be a hearing, and it's about the third motion to compel. It's going to be all about this DNA discussion. I can't wait to hear the outcome of that. If there's anything to show you, I'll show you when I can. As you know, I'm covering a trial at the moment as well. Come and join us in the chat, whether you pop in or out, or just listen to us, while you're at work. I know some people do that as well. Put those AirPods in and join us. So come say hi. I will see you later. Thank you so much. It's time to hydrate, get my voice ready for later. Yes, I'll see you soon. Okay, by the time you watch through this, we're going to be live with the trial. So thank you so much. Please like the video, share, hashtag Idaho case, Idaho for Idaho students, Bryan Kohberger, Grizzly True Crime. Those all work great. So thank you so much. And see you in the next one. Bye.